Does the fact that New York State passed the Climate Act mean that no local governments can pass any laws about greenhouse gas emissions? To find out, you have to read Glen Oaks Village Owners versus City of New York, but it's 9 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Glen Oaks Village Owners versus City of New York. The citation for this case is 2025 New York Slip Opinion 03101, published by the New York Court of Appeals on May 22nd of 2025. The issue in this case is whether New York's Climate Act prevents any other municipality or locality from passing laws about climate change and greenhouse gas emission reductions. To understand and appreciate the context of this case, the helpful background to know is that the state constitution in New York basically says that New York State wins in a fight with local law. So if the New York State passes a law saying you have to walk on the sidewalk and the local law says you can't walk on the sidewalk, New York State law wins. You can't have local law that conflicts with state law. And if it does, the state law wins. That's called preemption. And there's 2 kinds of preemption. There's conflict preemption, where it's directly opposite. You know, the state says one thing and the locality says something else. And then there's field preemption. Field preemption is the state has spoken about an area, and because the state has spoken about an area in a way that shows they're trying to regulate that area, to control that area of the law, no locality can pass laws about that area anymore. The state has demonstrated an intent to legislate in this area to the exclusion of any other conflicting or different or dissimilar locality law. Okay, what are the facts in this case? The facts are that in May of 2019, the City of New York passed a law, Local Law 97, which had a lot of features, but basically it was a climate change reduction of greenhouse gas emissions law. It did a bunch of things. It forecast a minimum of 40% reduction in greenhouse gas emissions by 2030. It mandated a minimum of 80% reduction in emissions by 2050. And importantly, it created specific methods to calculate annual buildings emissions limits. It created emissions limits for buildings in New York. And it created an Office of Building Energy and Emissions Performance to oversee the emission standards and compliance with those rules that they set out. 1 month later, in June of 2019, 1 month later, the state of New York in Albany passed the Climate Act. And the Climate Act had it addressed climate change in different ways. It also had a target of at least 40% reduction by 2030, reduction of 100% by 2050, but importantly here, no specific emissions limits imposed by the Climate Act. Instead, it created a Climate Action Council and gave the council 2 years to prepare a scoping plan, and then directed DEC, the Department of Environmental Conservation, to create regulations consistent with that scoping plan to ensure the compliance with the rules that would come out. But lastly, it contained a savings clause that said this law is meant to work in coordination with other state entities, with localities, with municipalities. It's supposed to work in conjunction, or it's supposed to work alongside them. That's what the savings clause said. It said nothing in this act shall relieve any person, entity, or public agency of compliance with other applicable federal, state, or local laws or regulations, including state air and water quality requirements and other requirements for protecting public health or the environment. And it said nothing in this act shall limit the existing authority of the state entity to adopt and implement greenhouse gas emissions reductions measures. So at that point, the Glen Oaks building owners, representatives of the building, sued when it came time for them to comply with the city Local Law 97 emissions reduction levels. They sued and said, wait a second, this law is invalid because of the month later passed Climate Act by New York State. They said this law has now been preempted. The field has been preempted by the Climate Act. They weren't arguing conflict preemption. They were arguing field preemption. At first, the Supreme Court granted the defendant's motion, dismissed it, so agreed with the city. Then it went to the appellate division. The appellate division denied the motion as to preemption, but certified the question up to the Court of Appeals, said pass it on to the Court of Appeals. And the Court of Appeals here said the principal question we have to answer here is, what did the legislature of New York intend? If they intended by their Climate Act to preempt the field, then it does preempt the field. If they didn't, then it didn't. And so they say the way we have to figure this out is look at the law's structure, and particularly look at the savings clause. For the Court of Appeals, the savings clause saved the city, because they said the savings clause said here it recognized that local governments play an important role in the area. They weren't trying to stop local laws from coming out about emissions reduction. They were saying they recognized the importance of local laws in fighting climate change. And because of that savings clause and the importance of what it means for the intent of the legislature, there was no field preemption, and therefore Glen Oaks loses, the city law is saved, local law 97 survives, and the local buildings must comply with the specific emissions level reductions required by the city legislature. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.